on the Constitution in 1833. Justice Story was one of the greatest, and indeed the greatest, of the second generation of Supreme Court justices. And he wrote these commentaries where he went and looked at every provision in the Constitution and explained what it meant. So this was pretty important, an important clue as to the original meaning coming from such an eminent jurist as Justice Joseph Story. Here's what he said. The importance of this article will scarcely be doubted by any persons who have duly reflected upon the subject. The right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of the Republic, since it offers a strong moral check against the usurpation and arbitrary power of rulers, and will generally, even if these are successful in the first instance, enable the people to resist and triumph over them. That's not coming from some 20th century or 21st century, politician or gun enthusiast. That's coming from Justice Joseph Story. And again, a very important commentary on the meaning of the right to bear arms. Now let's fast forward to where we are today. As you know, as you probably know, in the Miller case in 1939, the Supreme Court, Roosevelt's court, wrote an opinion that gave a rather uninformed and I would say incorrect view of the Second Amendment. They tied the meaning of the Second Amendment so closely to the militia clause that they implied that the amendment only protected those weapons that were used by militias. Well, that record would be corrected 69 years later in the great decision of the District of Columbia versus Heller in 2008, where the Supreme Court at long last finally took the issue up and recognized unequivocally that the Second Amendment guarantees a right of an individual, not a right of a collective group like a National Guard unit, but the right of an individual to keep and bear arms, and that right extends to bearing a handgun in the home. And of course, it struck down the infamous DC gun ban. I would encourage you to actually read it. As a professor of law, I don't regularly tell people to go out and read Supreme Court opinions because I know how important your time is, and I know that some things will put you to sleep rather quickly. But Justice Scalia's opinion in the District of Columbia versus Heller is actually really good reading. I think it's one of his best opinions in his entire career on the court. And it's not that long. It's written in layman's terms. It's as if he is writing to the American people, because he is indeed writing to the American people. He's not just writing to a bunch of lawyers. And so check it out. Go home and Google it. Just Google DC versus Heller and just an opinion of the majority by Justice Scalia. And you should check it out. It is a really, really good read. There's great historical information there, and it shows how he gives a common sense understanding to the plain meaning of the Second Amendment. So definitely take a look at that. But of course, it was a great thing that the Supreme Court corrected the historical record on the meaning of the Second Amendment. But the most astounding thing to me about District of Columbia versus Heller was not Scalia's opinion, but the fact that 4 Supreme Court justices disagreed. It was a 5-4 decision. That's painfully close. That should have been a 9-0 decision with no concurrences, no dissents. It should have been self-evident that every word of Justice Scalia's opinion was true. So there's a powerful warning there that shows just how precarious our Second Amendment rights are and can be. One justice away from eviscerating those rights or greatly shrinking them if the 4 justices in the minority had had their way. And today, as you probably know, indeed it was mentioned in the introduction, we have the case of McDonald versus City of Chicago, a case where I've signed on as to an amicus brief, which is a friend of the court brief. And there, the question is the Second Amendment a fundamental right that should be incorporated against the states? For the past century, the Supreme Court has been incorporating one at a time all of the fundamental rights listed in the Bill of Rights, and from time to time inventing some new ones, but that's another discussion. And they have yet to incorporate the Second Amendment. Now, that's not because they have been willfully seeking to avoid it, but more that the case just didn't arise. And the District of Columbia versus Heller case did not involve a state. It involved the District of Columbia, which Congress has ultimate jurisdiction over. I'm confident that we will win in McDonald versus Chicago. I'm very confident that the court will incorporate the Second Amendment, and that will be the second chapter in the DC versus Heller case. And our rights will stand on much more secure footing when that opinion comes down, probably in the next couple of months. So we can look forward to that. But I just want to close by pointing out again that our Second Amendment rights are never entirely secure. I was kind of amused when I came over here today and I heard from Ben Davis, who's my campaign manager, that the yard signs would not be allowed, the political yard signs would not be allowed out here. And this is no commentary whatsoever on our fine police officers who are merely enforcing the regulations. They didn't write them. But it's a commentary on the regulations themselves. Why aren't the yard signs allowed? Well, because they have pokey metal sticks on them. And that could be dangerous. And dangerous things are the first things that are regulated. And so now even the little metal sticks on a yard sign are not permitted on the Capitol grounds. And again, it's the writers of the regulations who need to be questioned, not those who merely enforce the regulations. But think about that impulse. It's always the dangerous things that get regulated most easily and most quickly. And as long as there are liberal progressives roaming the halls of state capitol buildings and roaming the halls of city councils, there will always be people with an impulse to control or ban dangerous things. Whether those dangerous things be little metal sticks on a yard sign, cars, words, or guns. There are so many things that can be dangerous that there will always be an impulse upon those who believe in big government and overweening government to extend them into the sphere of our most treasured liberties, the Second Amendment. So I want to end on a sort of an ambivalent note. It's a time of great celebration in this country that we finally have District of Columbia versus Heller. We've corrected the historical record on the Second Amendment, but we must also be so cautious. 4 justices voted the wrong way in DC versus Heller. There will always be regulations attempting to cut back our rights to bear arms. And I encourage you and thank you for standing up for those rights, and thanks for being here today. It's been my pleasure.